Everyone, welcome. I'm Peter Csathy, and welcome to this great digital Hollywood session that is called HAL 9000 Meets Madison Avenue. AI agents, training and copyright, the worst case scenario. But we'll talk about some best case scenarios too. And I have a great panel. I'll introduce them in a second. But first, just a little bit about me. So I'm very deeply involved in the AI space, working with both with agencies, media companies, and the big tech companies to try to solve the problem, take away the friction, bring them together to enter into deals, essentially mutual win-win opportunities in this AI transformation. So the issues that we're going to be talking about today, many of them are friction-based, but that's where I'm involved in. And if anybody's interested in following these issues of AI in the agency space and media and entertainment space, you can check out my The Brain newsletter that's on Substack. So I write about all these issues. And that's enough about me. Now we'll introduce the different players that's on this great panel. So Chad Hummel is a partner at McKool Smith. And Chad, I'll kick it off to you to give a little bit of your background.
Sure. Hi, everybody. I'm Chad Hummel. I'm a partner at McKool Smith, as Peter said, based in Los Angeles. I've been trying cases throughout the country in all kinds of fields for more than 36 years, including in the IP space. I've tried cases relating to the misuse of name, image, and likeness. I've tried class actions and have now become sort of deeply involved in not only monitoring, but in advising clients throughout the country about appropriate uses of AI. And in particular, I've litigated false advertising matters under the Lanham Act and state non-deception statutes. So with that, that's enough of an intro about me. By the way, Peter and I grew up together in Minnesota. So
yes, we did. We are hardcore Vikings fans, but that hurts a lot all the time. So I'll hand it off to Meeka Bondy.
Hi, I'm Meeka Bondy.
Yeah, that's what Peter... I thought, but I'm sorry about that. I misspelled it on my page. But Meeka, Perkins Coie, why don't you give an introduction after my wonderful introduction of you?
Great to see you, Peter, at another AI panel. Last time I was the moderator and you were the speaker, so we've switched roles, but It's great to be here. I've been a media, entertainment, and technology transactions lawyer since the dawn of the internet. I've had prior in-house stints at HBO, Time Warner Interactive Video Group, and Timing Interactive. And right now I'm at an AmLaw law firm that you may have heard about called Perkins Coie. And I'm here as senior counsel in their technology transactions and privacy group out of the New York office. And I'm also co-chair of their film and TV practice. And I represent clients when they're navigating media rights and distribution models across all types of audiovisual content. I also help them on their high stakes content licensing, development, and distribution agreements, and also advise content and technology companies on emerging technologies like AI. That's enough about me. Back to you, Peter.
Yeah, thanks, Meeka. I appreciate that. And then next, Steve Masur, who's from Raines Feldman and Luttrell.
Hi, I'm Steve Masur. Very much like Meeka, I've been working in the internet space since the early days. 93 is when I started. And I just became obsessed with it and never stopped. And I come from the entertainment industry too. I was listening to Meeka's introduction, and it's very similar to mine. So I have an entertainment practice, and I'm the chair of the technology and ventures practice group. My work comprises a lot of venture-backed deals, as well as work in the similar areas as Meeka and Charles mentioned, which is doing AI, working with a bunch of AI companies, a few companies in the decentralized AI space, which is a new area, and very interested in this conversation about copyright and fair use as it relates to AI and advertising and what we're going to see next.
Great. Thanks, Steve. Appreciate it. And now for a non-lawyer in the group. So we add some great expertise on the business side, particularly when it comes to the creative side. And Bharad, Ramesh, why don't you give an introduction of yourself?
Thanks, Peter. Hi, everyone. I'm Bharad Ramesh. I am the CEO and co-founder of Aqxle AI. I was previously running measurement and analytics at Group M. Aqxle is built to solve one fundamental problem, is the inability of a lot of marketers to go from data to actionable insights very quickly. So using our patent pending algorithm, we help marketers do just that. And what's interesting for me to see with AI is that the market that VCs want to see us disrupt, and which we think we will disrupt, is the labor market, which is the total addressable market of people doing jobs that the AI agents can do. And that's the sensitivity and the perspective I bring to this particular panel. And I hope to contribute and learn from it. Thanks again.
Great. So it's an excellent panel that we have today. And although we have a number of lawyers on this, because we're going to get into some of the critical legal issues, we're going to keep it at a high level and make it practical for people who are in the advertising and marketing and media businesses. So that's the goal today. So we'll start kind of at a macro level, and then we'll drill down. And first, I want to ask everybody to kind of set the stage of just giving some specific examples that you have in mind of some transformational marketing ads that you've seen that have used AI in a significant way. And I'll kick things off just to kind of help set the tone for everybody who's out there watching and listening. This past December, the most pivotal advertising campaign that we saw, at least in the United States, was the holidays are coming Coke ad. That was something that was discussed far and wide. It was deeply accepted. Consumer sentiment about it was very, very high. It scored highly. I recently interviewed Eric Shamlin, who's the CEO of the advertising agency that created that ad. Secret Level, I think, is the name. And we talked about it. I asked him about the overall ad and how he was able to do it. And it was essentially all AI generated, although it was based on humans who were performing certain things as part of the advertisement. But it was really pretty much AI generated. And that was, like I said, it was this kind of fantastical ad with the Coke polar bears, and it received very well by the consumers and by others, I think, in the brand world. But from a lot of creatives, it received a lot of industry blowback for a number of the issues that we're talking about today. First of all, it's the job replacement concern, which is a justifiable concern, of course, for everybody who's out there and listening to this. And we'll get into that a little bit more. But then certainly when it comes to also infringement issues, and we'll get into some of that, because at a very high level, when we're talking about infringement, there's multiple potentials, and I won't touch upon that yet, but that's just kind of a pin that we'll get into a little bit later. So that's my transformational ad example. And who else would like to give theirs at this point?
I think my favorite one is the one with Elon Musk, and that riffs off Blade Runner. So on October 10th of 2024, he staged a presentation to launch his robotaxi, and it was done on the Warner Brothers lot. And he drove up in the prototype, and as he entered the stage, they showed some images and some video, and there was an 11-second clip that had a male figure in a trench coat looking across what looked like the ruins of a city in a sort of misty orange light, and very much looked like a scene out of Blade Runner 2049. Actually, I shouldn't say it looked like it. It might look like, to some, like a scene out of Blade Runner 2049.
It looked like it. I'll say it.
I don't want to take sides here. And Alcon Entertainment, who is the production company for Blade Runner 2049, actually brought a lawsuit. And it was based on both trademark infringement and copyright infringement. And just a few days ago, actually, the court just dismissed the trademark infringement claims. I think there were some buried references to the movie in the clip, but they allow the copyright claims to continue. So it'll be an interesting issue of whether that scene is copyrightable to the extent that you can't use an AI generated clip based on that scene. But I thought that was one of my favorites.
Yeah, it's a good example. Anybody else want to throw out an example before we get into the more in-depth discussion?
Well, I can throw out an example, Peter, of an AI ad. It has no litigation related story to it, but my favorite one, because I'm a tennis fan, is the Nike ad using Serena Williams where she's playing her younger self. That is if you haven't watched that, it's amazing. I think they like used footage of her 1999 win in a Grand Slam against her 2017 version of herself in the Australian Open. And that ties to an app where you get perfect Nike shoe recommendations for your own foot. I mean, it is a really cool use of technology to get people interested in the sport, interested in her. To my knowledge, it was all consented to and all compensated, which are the issues we should talk about today. But that is a really cool use of AI in advertising. To me, it's the best one.
Yeah, that's another great example.
Yeah, I mean, my example is really just that the use of AI in the hands of good artists is really going to produce some incredible things, as we've heard from everyone's examples. And I think we're really just at the beginning of that. And that we should see AI as a tool for creatives more than we see it as a sort of the demise of creatives.
Yeah, Bharad.
So I am coming from the other side, from a content production perspective. The Chinese TV manufacturer TCL, they launched a streaming fast channel, TCS Plus, late last year. And that channel had actual episodes of AI generated content, let alone the advertising piece, right? So we are going to live in a world, in the only constraint being the cost of compute, where you can have entire channels and networks, and YouTube already has it, of 100% AI generated content that serves as entertainment and for an advertiser inventory to put their ads against, which kind of disrupts the entire content marketplace.
Well, it's exciting, but I think the reason I didn't mention an example is because I haven't seen anything great. I think we really have to, temper our statements by saying it's got to be good for people to like it. And I haven't seen a lot of that. Like the uses have still been a little bit run of the mill and similar looking.
Yeah,
Where I've seen this being used, Peter, is where a retailer, it is out of Australia, an Australian retailer, they're doing their catalogs, right, with a shoe and a model wearing a different shoe or wearing a different dress, completely AI generated, right? The models are AI generated, the locations are AI generated, the shoe. I mean, the initial shoot is real, but after that, the shoe colors are all different. So what would take them a month or two to plan out the photo shoot for the catalog is now being done in 2 weeks at a fraction of a cost using no talent. And that is the below the surface ads of what you see, but you don't see all the creative work that's happening below the surface. And that's definitely a place where things are already happening today.
Yeah, absolutely. And let's not forget that we're just a little bit over 2 years since ChatGPT was first launched. So it's still extremely early days, and we're already seeing the kind of innovation that you're talking about. And it's only going up like very, very fast. And why this all matters to everybody who's listening out there in the advertising and media world in general is that there are risks, multiple types of risks that are involved. Obviously, there's the creative blowback risk, which is understandable given the fact of what everybody's touched upon is that there is going to be a reduction in traditional jobs in the advertising side because of the efficiencies that come with what we're talking about. There may be some new jobs that are created, absolutely. So nobody knows how this is going to play out. But certainly there's the substitution impact. And so there's creative blowback that is holding things back. But it's not just that. It's the risks that are associated, and we're going to dig into many of them, but we'll start with the most obvious ones or the most discussed ones, which is copyright and copyright infringement. And the reason why that matters to everybody out there is because it impacts your business given the risks that are involved. But so let's touch upon it without going too deeply into it, in just discussing the different forms of potential infringement that come into play with generative AI. And there's a few different categories of that. And Meeka, why don't I ask you to lay that out if you can, when we start talking about the training, RAG, and then on the output side.
Yeah, so I think there are kind of two sort of issues going on, or maybe more. But one issue is about whether AI generated content is copyrightable in the first place. So that's sort of one issue. The other issue is whether you can basically make copies of creative works, ingest those copies, and use them to train your AI tools. There's a lot of litigation around that. And there's also potential litigation around the output. So for example, you might put into a prompt, please provide a painting in the style of your favorite whoever. And so there's litigation around that. And so I'll just start with the copyrightability question. So the first thing that happened was a computer scientist named Stephen Thaler created an AI called the Creativity Machine. And the Creativity Machine created a painting called A Recent Entrance to Paradise. And he tried to register that not in his name, but in the name of the AI Creativity Machine as the sole author of that AI generated painting. He did not claim that he made any sort of human contributions to the work. The Copyright Office said, no, sorry, you have to have some sort of human contribution to qualify for copyright protection under, honestly, it comes from the United States Constitution, to be an author, to be an author to be able to protect your works. And so a recent court confirmed that ruling, and saying that human authorship is a bedrock of copyright law. And then the next set of copyright registrations try to move towards, okay, I can't register it if it's completely AI generated, but let's say I'm a human and I use tools, and artists use tools, right, to create creative works. And some of these artists try to use some AI tools and get copyright protection. We have yet to get copyright protection over a fully AI generated piece of work outside of what they call the selection, coordination, and arrangement of the work. So there is a thinner copyright protection that you can get over the selection, coordination, and arrangement of a work. And just to give some concrete examples, there was a graphic novel that tried to register for copyright protection, and they did provide copyright protection to the selection, coordination, and arrangement of Zaraya of the Dawn. But they did not allow for copyright protection over any of the fully AI-generated elements or images within that overall graphic novel. Another example is there's a
Meeka, can I ask you?
Sure.
Can I ask you a question about that?
Yes.
So that's an interesting point right there with respect to the example I gave, the polar bear ad, because if that was truly, essentially all AI generated, what do you think? What do you think that issue applies of whether there's even any kind or sufficient human interactivity for that famous Coke ad to be copyrightable?
If it was fully AI generated, the Copyright Office might say that any of the individual works, images that were fully AI generated don't get copyright protection, but presumably there was an advertising creative person involved with putting together the story, the flow, what the advertising was, right? Like for which product. And so that piece of it, how that flowed, would still be potentially copyrightable as in terms of the selection, coordination, and arrangement of the work. And just to go further,
it's coming out in terms of an amount of creative involvement. I think with Zaraya of the Dawn, they actually presented in court that they had photoshopped the lips of Zaraya, and it was ruled not enough human interaction.
Yeah, and then there's been some more cases that are pushing the limits a little bit, but still we don't have actual. So for example, there's a painting called A Single Piece of American Cheese, and it was created by somebody from Invoke, the CEO, and he used a tool and created the image, the first image, and then he used their in-painting tool to edit 35 different parts of the picture, using this in-painting tool to sort of AI generate those little sections. So the Copyright Office did allow for copyright registration, but it was limited to the selection, coordination, and arrangement of that image because he had selected those 35 spots to sort of edit and customize. But again, the actual image, the start of that image was not copyrightable because it was fully AI generated.
Gotcha. Okay, and then continue, just briefly touch upon any of the other elements of copyright, on the copyright infringement issue.
Yeah, so there's a whole host of lawsuits right now saying that copyright creators are bringing. So for example, publishers, artists, authors, songwriters, even computer programmers, saying that when the AI developers are basically scraping their data and their copyrighted works from the internet, ingesting that stuff and using it to train their AI, that is copyright infringement because they've taken a copy of their copyrighted works without credit, without compensation, and without consent, and used it to train their AI. There are obviously counter arguments that some of these AI developers are claiming, including fair use. And the claim there is, I am, taking that copyrighted work to create a new transformative use, which is the AI tool itself. But there's some case law around that, but the fair use analysis is complicated, fact specific, and that is where a lot of the AI developers are making the claim that they're not engaged in copyright infringement because they're excused under the fair use doctrine. But the other thing to know on these litigations is that a lot of them have narrowed, so now only the direct infringement claims remain. A lot of the other like trademark related claims, state unfair competition claims, a lot of those sorts of claims were dismissed in a lot of these cases.
Right. And the fair use balancing test, a way to think, a simple way to think, if there is a simple way to think about it, is that it's between the public interest of whatever the fair use is purported to be, meaning education or news gathering, or two or three other of those tests. And the test is that it is not substantially harming the market for the original work. So that's the hard part, is to figure out whether an enhanced AI image harms the market for the original work.
Yeah, I mean, there's a lot of complexity that gets into it, and we'll try to touch upon it if there's time at the end of this session to get a little bit deeper than that. But at a very high level, as you both said, it's the fundamental claim of whether something's copyrightable, and then if it is copyrightable, and then there's training or some other kind of use of that work as part of the overall AI process, whether it's for training, whether it's for actually creating and generating the output. And a claim is made that there's infringement, then as Meeka was saying, and as Steve were saying, they were saying that the fair use defense is really a public policy, but it is a defense. It is a defense to infringement that has to be asserted by that. And then I want to ask you,
it's worth just running through how limited fair use is, so that we know how much of a defense it is. Criticism, comments, news reporting, scholarship, teaching, and research is what you can claim fair use for. So
I would probably expand that a little bit, especially in the technology space, because there's this recent Thomson Reuters versus Ross Intelligence case, which was the first substantive fair use decision in the AI space, but not generative AI. So it still remains open how it's going to affect generative AI. But in the Ross Intelligence case, they lost the fair use defense. And the reason is because they supposedly
they as the defendant in this case, just to be very clear.
Ross Intelligence supposedly took copyrighted works from Thomson Reuters, which were their head notes, the Westlaw legal research database. A lot of us lawyers know what that is. They used the keynotes from that to create questions to train their legal research AI tool. But the court said that fair use didn't apply here because they copied without permission to create a competing legal research tool. Therefore, it was not transformative. Therefore, it did not qualify for fair use protection.
Right.
I think in the generative AI case, you're taking books, songs, articles, other copyrighted works to train, not to create competing songs necessarily. In some cases you might, but to create an AI tool that could create both competing and infringing works, as well as transformative and non-infringing works.
So
the question will be whether
I want to step in.
I'm going to Steve, hold on 1 second. I got to jump in here. Okay, so I believe, and I'm a lawyer by trade, so I understand the intellectual property issues. Nobody knows here, and I don't want to get any deeper than this on this particular because we have to move on. But I believe that the Thomson Reuters case, even though it was not in the generative AI context, it was talking about training on copyrighted works. That was really the fundamental core of it. So the outcome, which was a win for the plaintiffs who are the rights holders, I would say that that rationale, and it was the market substitution rationale, will apply whether it's generative AI or not generative AI. So that's how I feel it's going to work out. Meeka and I may disagree on it, but I want to move beyond fair use a little bit now because we
Well,
talked
it's
about
only U.S. law. That's the point I was going to make.
No,
Only US.
Exactly.
sure.
I was about to add to that.
Yeah, very good point as well. Yes.
Yeah, that's a great point because all the 200 territories in the world have different copyright.
We live in the internet, and AI is a product of the internet.
It is.
I agree. My only build on that is I know we're going to get past the topic as a startup, and I work with data sets. I need access to the data. So I rely on the user who has fair use access to share the data with me, right? But it's amazing to see how many data owners put a price on data that makes it impossible for startups like mine to grow, right? Because they believe, right or wrong, the data is worth so much. And so when my startup doesn't grow because of these kind of issues, meanwhile, in Japan, if you Google Japan copyright AI law, it's actually far more permissible than US AI law. Meanwhile, a startup in Japan is not constrained by the limits I have operating in the US, right? So that puts me behind. When it comes to these kind of use cases. And my advisor, one of whom is from North Asia, is like, why don't you move your entire thing to Japan? Right? Because then it's not as clear cut as it is in the US. So there needs to be a balance here.
No, there needs to be a balance, but that's a very, don't take this the wrong way, Bharad, but that's a very Silicon Valley based argument that, you're slowing us down. At the same time, we have creatives who created the content that is the fuel to give value.
If you're a multi-billion-dollar company doing this, of course, right? But if I'm a startup and I'm willing to work on a revenue share model or kind of like a data as a service model with these providers, but they're refusing to do so either. So it's not like so there must be different models that the data owners should be willing to work with depending on the type of company they're working with, right?
I 100%
agree. My point is just that the elephant of cross-border, of the internet being cross-border, is always in the room.
Sure.
And we really need to come up with some kind of regulation for the internet. I mean, that's the reality of it. We're just not going to be able to maintain territoriality.
Yeah. And that's where, to give it the best shot, it's stripping away the litigation and finding a way for the industry to work together and enter into some kind of arrangements and compensation schemes to be able to take that friction away and so that we can progress. But Chad, I want to hand it over to you. We talked about copyright, but there are other issues that come into play, like in terms of risks of misleading, deceptive ads, things like that, but also get into some of the non-contractual issues that I know you've looked into, but at a high level.
Well, let's talk about it at the highest level, right? And Bharad, I think this is going to address exactly what you said in a different way. As a trial lawyer, here's how I think about it. And if I'm going to present this, here's what these generative AI companies are doing. They are taking data, whether it's ones and zeros or images or copyrighted works, and they're largely doing it without consent and without compensation, right? And so the rubric we're trying to get to is what's the right way to get consent for the copyrighted work or the image or the likeness or the biometric data, which is something that most people don't even think about at this point. But there are now increasing uses in various states of statutes to prevent the taking of biometric data of people, converting it to ones and zeros, and then using it to generate, AI content, right? So what are the risks? And again, Peter, I'll keep this at a very high level and tie it specifically to advertising. So if you're put aside, and Meeka, this is your point, right? Put aside what people are bringing in from the scraping and putting it into the machine, the model, right? And what is the output? Is that copyrightable or not? Those are interesting questions. But here in the advertising field, you've got to make sure that the ads generated are not deceptive. That is, they're not literally false. And who knows what AI is putting out there, right? And in the traditional advertising world, they can't be impliedly false, meaning they're not generating a false impression to a significant minority of consumers. How do companies defend against those cases? by saying we have substantiation for those claims. Okay? There's proof that they're true, even if there's a claim that they're somehow impliedly deceptive.
Yeah.
What is the proof going to be when an AI-generated ad is challenged under the Lanham Act? How are you going to prove substantiation? Well, my model generated it, probably not going to fly. So as people, and Meeka, I see you smiling because I know you're in this space, maybe not as a litigator, but you think about it all the time. How do you protect companies from generating impliedly false ads in this space? Peter, I'm just issue spotting here. The other one is,
it's
right,
a good one.
If you're using somebody's image, voice, likeness without consent, you're running a risk of violating a right of publicity or a privacy claim under state law. And again, this is U.S. limited. I recognize that. And it may be even
Chad,
more.
can I ask
Go
you
ahead,
about
Peter.
that? Yeah. In the obvious case, when it's clear that you're using somebody because there's some kind of on the output side, it's very similar. But is there, substantially similar or something that is it's you can see it, or hear it.
Yeah.
But is there even a risk if the individual is just part of a training data set and there's no resemblance of any kind on the outside?
Well, so that's not yet decided, right? That is in the right of publicity area, which is heavily litigated, has been for many, many years. Peter, that issue I think is ripe for decision. Those cases have not been brought largely because we as lawyers, guess what? We want to make money. And those cases are not subject to class action certification,
Well,
right? Because
one
they're
thing I would just
individual.
add, though, on right of publicity is that most of them require there's a commercial use of someone's name, image, and likeness, sometimes voice.
Right.
So it has to be some sort of commercial use. So if it's just a copying, it may or may not, depending on whether you write. It's not out there necessarily. So it's slightly different, I guess, analysis than under copyright law, I think.
Well, Meeka, I would say though,
I would disagree with that.
Let me just say one thing, Peter, before you jump in as the moderator, and I know you control me in so many ways. Try not to do it here. I'm just I made him laugh. Hey, so so Meeka, the question is going to be, is the scraping and the use in training use for purposes of, and I use the Chris Farley quotes, use for purposes of right of publicity law? It's not decided. I think you have the better analysis that it's not likely a violation, but the courts could go there. The final thing I wanted to say is be mindful of the biometric data statutes. Increasing numbers of states are passing what are called private rights of action, meaning citizens can bring claims on their own. My firm, and I don't mean to tout my firm that much, just settled the biggest biometric data case against Meta for the improper use of biometric data of citizens, but it had to be brought in the name of the Texas State Attorney General. There was no private right of action. So as we move forward in this, and there's an increasing use by advertisers, content generators of biometric data, those statutes are ones to be watching. I don't know if that's teed it up for you, Peter, as the non-contractual issues.
No, I think that's really good. When we step back from all of this, from copyright, some of the trademark sorts of things, whether it's deep fakes this bucket of risks. The point is that for everybody who's listening, it may sound kind of far afield of what you do, but the use of AI itself, you need to understand these issues as you create, as you plan your next campaign of some kind, because there's both the potential direct liability, but is there also potential secondary liability of some kind? Or is it just, does that come into play at all when we're talking about in the advertising space?
Well, there are bodies under copyright law, there's contributory liability and vicarious liability and other forms of indirect liability, where you are not necessarily the one who engaged in the infringement act itself, but you either facilitated it or knew and should have known about it and didn't stop it, and there are liability theories like that. But that would be really under copyright law. Under right of publicity law, it would be more probably, and Chad, you're probably more of an expert, it would be more like unfair competition type claims might come out, misappropriation type claims under state law. But this is more for a trial lawyer to figure out what to put into the complaint.
And that's right. And the truth is, there's no clear answer at this point as to that, Peter, in my view.
Yeah, and that's the reality of it all. There's some great tools out there. They're getting more and more sophisticated, but it's critical to understand this landscape before you implement them on behalf of yourself and for your clients. And then before we go on to a different topic, I do want to ask Meeka, one of the things that we wanted to talk about also is a little bit out of the advertising more and just getting into liability for different kind of use cases that are quite interesting and novel. And one of them was this with respect to AI relationships. And, I want you to talk about that just a little bit because it's such an important case of this shows you where there's kind of the unknowns out there, how AI is going to be used. And nobody intended it to lead to these kind of results, but this is the kind of thing that's almost unforeseeable. But I think you know which one I'm talking about.
Yes. So there's some people are saying that 2025 is a year of agentic AI, meaning AI agents, as opposed to generative AI.
Yeah.
And we're seeing some of that in chatbots. Chatbots are AI agents. And starting with a less serious case, which was the Air Canada case, where they had a chatbot customer service who was interacting with a customer who was asking about their bereavement refund policy. The chatbot gave them the wrong instructions. And for some strange reason, Air Canada brought a lawsuit in small claims court in Canada and lost because the court said, sorry, you put this person out as this chatbot out as your customer service rep. And so you have to stand behind what that rep did. And so it's almost like you just have to stand behind what you put out there and how you presented that chatbot to the consumer. On a more serious and more tragic front, there have been avatars and AI-generated characters that people interact with. And there was one case where a Florida teen committed suicide after interacting with an avatar that he named Daenerys, or they named Daenerys. There was also a man out of Belgium who was interacting with an AI agent about climate change and felt despair and killed himself. And both the mother and the wife of these individuals are claiming that they were interacting with the AI agent closely, right before their death, and they think it wouldn't have happened maybe if that hadn't happened. These are, of course, tragic scenarios, and these kinds of interactions with AI, they're becoming more emotionally intelligent, right?
Yeah.
They're much more interactive. They feel real. You, as a human, can develop an emotional attachment to these avatars and characters. And so I think there's going to have to be a lot of disclosure, a lot of education, and guardrails, right? All of these AI tool developers are going to, even if they get out of the lawsuit, right? It's a PR problem as well. So they want to. I think most AI developers want to be on the good side of this stuff, and not on the bad side of this stuff. But of course, it has tremendous other kinds of great use cases like therapy, right? Very private kind of therapy that you can have, less expensive therapy, right, than going to see a person. Of course, that goes to displacement and workforce issues. But I think in the healthcare context, being able to have an assistant or being able to converse with somebody about your healthcare, or even having them know more about you than you even know about yourself. I mean, there's so many great kinds of applications for this more interactive, more human kind of AI. But of course, the risks are they're not human and they can malfunction.
It sounds
just like humans can, but it's different when they do it.
On those tragic cases that you were talking about, it sounds like product liability almost.
Yes.
So that's going to be fascinating to watch because AI is not completely controllable. That's so nobody knows how some of these things will play out for sure.
Yeah, and I don't know this area well, but there is some sort of lawmaking or litigation around whether algorithms and software can really be subject to product liability claims the same way products can.
Yeah,
So-
that's interesting. That's a very interesting thought, because the AI do not think like humans. You know, this is sort of the common misconception and fear that AI tools, they're really tools, and they behave like tools. They don't have context the way that we have it, and it's I just think people have too many fears. They think of AI developing, but they don't think of the world developing at the same time that AI is developing. And yes, there's always a chance with any new technology that technology could cook us. I mean, certainly nuclear war, nuclear technology had that possibility as well. But I think we should really keep AI in the context of a constantly changing world in which AI is also constantly changing.
Yeah, there's the optimistic tone, which is really important to have as well, because nobody knows how this plays out. But Bharad, we only have about 8 minutes left, and let's get into, the topic. I don't know if it's the best name, but we're talking about the worst case scenario. But let's talk about just scenarios. You work closely with the creative or with the marketing community and with brands. What is the sentiment that you are getting from just the prospects of the impact on the human factor, on the jobs industry? Then we'll get into the impact on creativity itself. But what are you hearing?
I think the people who are doing these jobs, whether they are marketers, marketing operations, creatives and agencies, media planners, insights folks, they are underplaying or they're in denial, is my sense. So I'm looking at a forecast, not today, right? I'm looking at 2028 as that's my goal. People are underplaying. Oh, it's not great yet. It still needs people. I'm like, yes, it needs all of that. So I think there's a bit of a sense of fog saying it's not going to be as worse as we think. Look at what AI is doing today. And we went through the digital revolution that our jobs are supposed to be transformed. Nothing really happened, right? I think they're in denial is my most optimistic scenario, because the reality is that if you talk to startups and when you pitch to investors, it's the labor market that's going to be transformed.
Yeah.
Right? That's what's going to happen. You still need people, but do I need people with 0 to 2 years experience when I have an agent who can do the job, and I have someone with 3 or 4 years of experience, the so-called manager or supervisor, who can just look at it and start using that agent, right? So 0 to 2 years, that job market is something that the agents are replacing. And I think among the practitioners today, there's a bit of denial about that reality.
Yeah. And here's another, by the way, that's so true, that I think that the vast majority of people out there who are in our world of media, marketing, agencies, creative agencies, don't understand how fast this is moving. And here's an example, this is what's happening right now. How many of us use ChatGPT or chat-based search on a regular basis? Probably all of us, right? All of us do. Well, think about that. Think about what the impact is. Google has owned the landscape of traditional search now for a couple decades, right? Well, we are moving into a world of prompt-based search. That's the reality. In Gartner, research group Gartner is projecting that by next year, 25% of traditional search will go away. And the studies show that, at least one study that I recently saw, show that in chat-based search, there are 97% fewer referrals to websites that come from that. So for all of you who are listening out there, think about what that means to your clients and to your businesses, because that is a massive impact on our world. And then finally, because we all have just a short period of time, I'm just going to go around the room here, and I'll start with you, Chad. What's your words of wisdom to the audience out there in marketing and brand land about what to do with all this information we've thrown about, and how to best prepare themselves for the world that we are transforming into?
Wow, big open-ended question. I
Yes.
guess my fundamental advice is don't lose the human connection, right? So there's going to be AI generated creative, which will be either for marketing function or entertainment function or whatever it is. In this particular context, it is still important to have traditional advertising review, which exists at every company, right? Put it through the human ringer test for substantiation, make sure there's not literally false claims, keep that connection. And I would argue, and I'm not the guy here, I'm just the lawyer, but keep the creative connection as well. I don't care how sophisticated AI gets. The human creative factor, and Meeka, this is what you were talking about before, is the copyrightable. Keep that human connection, however you do it. And Peter, I don't even know what that means in most of these contexts. And Bharad, you're so million years ahead of how I'm thinking about it that I can't even, almost keep track. But it is, to me, very critical from a legal risk mitigation perspective to keep the content review processes in place. That's sort of.
I think it's a great thought. And Steve, how about your parting thoughts to the audience out there?
Use the tools. I mean, there's a lot of talk about AI and there's a lot of ignorance about AI. And to overcome the ignorance, use the tools and see how they work. See how they work for you. Fear is a great way to identify problems and a terrible way to fix them. Instead, we should learn AI and learn how it can help us, learn how, is it going to replace my job? Probably not. It's going to help my job. I'm going to get better, or I'm going to go off and do something else. And that's how we should think of AI. It's a tool set that we should be using, or we're going to fall behind.
And Meeka, how about you?
I would say perspective. I think that a lot of companies, to some of your points, have their heads in the sand. And so I think it requires thought and it requires thought leadership. And you need to have a lot of different voices at the table to figure this stuff out within a company. You should have an acceptable use policy. So if you need one, there are lawyers here. I'd be one of them that would be able to help you. You need to think about, are other people, ripping off our content and moving ahead with new businesses that we can no longer participate in? Do we need to train up our people to use AI so they don't fall behind our competitors? I mean, I think you have to have an AI task force of sorts to look at how AI is going to impact your company as a user, if you're developing it, if you're in the creative space. So that would be what I would say, is have some perspective with different voices at the table.
And Bharad, what do you think? What are your parting thoughts to the audience?
Look, I jumped into this leaving my job because I felt this wave was coming. And the only way I'm going to ride this is, I got to jump into it and learn by doing. I think the creative industry and the creative class has been for the last 20 years buffeted by so many forces of change, right? So I think we're a fairly resilient community from that perspective. But I think we need to build more resilience, learn more, and be prepared to be our own agents and our own employees and employers, because that's the future we have to prepare for. I hope it doesn't come true for all of us, most of us, but we have to be prepared and not ignore it. And I think universities that are teaching courses in creativity, advertising, filmmaking, they need, and who are incubating this student talent, need to integrate this. AI is not something that sits in the physics and computing school. It's impacting the jobs of these graduates when they graduate 2-3 years from now. And I think
Including
that's
lawyers.
something that,
Yeah,
Harvey.
including us. Absolutely.
Everybody. I mean, my son just graduated from NYU Film School, and he's a filmmaker. And and he's pretty sophisticated with tools. But are we going to look back and say NYU Film School, one of the most expensive schools in the world, is that worthwhile? And I still believe that interacting, the human quality, the things that you were talking about, Chad, I don't believe the human factor goes away, but everybody said some critical points. And I think that at its core, there is a lot of fear out there, which is understandable for everybody who's listening. It's very understandable. But the only way, I shouldn't say the only way, because you can stay in fear, but I try to be stoic about it. That's the word that I use. It kind of is what it is. So what can you do to control? You can't control what's happening outside of yourself, but you can control how you react to it. And the advice that you all gave about that, which is becoming active, not a passive participant, experimenting, playing with the tools, learning about it, listening to the smart people here who are in the room, listening to their counsel, their advice. Those are critical things to do. So I urge all of you to do that. Look up everybody's bios, reach out to them. If you're interested in learning any more, you can follow my Substack. It's called again, The Brain, themediabrain.at substack.com, and reach out to all of us with any questions that you may have. But I really appreciate all of you joining on this panel. It's excellent. We could talk about this for a long, long time. You have such great expertise. And for the audience, I hope you got a lot out of it. These are great experts in the space. So thanks for joining us on this session.
Bye,
Thank
guys.
you.
Thank you.
Thank
Thank
you.
you.